话筒连接成功。
Okay, that's everything. We talked about these service schedules, and we'll move on. On this page, it's about trips, the 1C. Yes, it's also an important annex to the WTO agreement, the principal source of WTO law. Okay? And you need to pay attention to this part. Minimum standards of protection and effective enforcement. My question would be, how would these obligations be enforced? I mean, through which mechanism or system can the minimum standards be enforced? It's called WTO Dispute Settlement Mechanism, DSM, right? Good. And here, these words in red are important, and I will not make more introduction. What about this part? Yeah, TRIPS actually incorporates by reference to some other international agreements. For example, this one, the Paris Convention. What is Paris Convention about? Paris Convention. It's about what? Industrial property rights. Industrial property rights. Then what are included in industrial property rights? There are two. They are how many categories of intellectual property rights are there in total? You learned. 3, right? What are they? Trademarks. Good. Very good. And you should be here. What else? Patents. Patents. Good. And in this, what about this convention? This we call it Berne Convention. And what's Berne Convention about? Berne Convention is about the remaining one, the last one. Patents, trademarks, copyrights. Right? Copyrights. Okay? Good. That means all these two conventions are incorporated into TRIPS. Good. On this page, it's about DSU. DSU is annex to WTO agreement. Annex 2, right? DSU. It's about dispute settlement understanding. It's a short name for this one. Okay, good. And you need to know is that DSU is arguably. That means it's not for sure. Arguably. Can be argued. Arguably the single most important achievement of the Uruguay round negotiations. Okay. And these are the characteristics of DSM. Characteristics of the DSM. And this part, the names of all these articles of DSU. Okay? There's one thing I need to point out. Because in the future, when you are reading academic papers, in the Journal of International Economic Law, for example, you will always encounter this word. It's called covered agreements. What does this word mean? Covered agreements. Cover. There is a cover to this bottle. Cover. This is the cover, right? Cover. covered. Then, covered agreements like this, like GATT 1994 is a cover to these 13 agreements, right? It's a cover. Like the WTO agreement, the principal source is a cover for all those annexes, right? Then, what does these covered agreements mean? For example, in an academic paper or article, what does it mean? Does it refer to these 13 specific agreements? Does it refer to all these annexes? 1A, 1B, 1C, 2, 3, plurilateral ones? Oh, what's the meaning of covered agreement? I will tell you. It's something specific to DSU. It means all those agreements that is subject to DSM. You got it? For example, 1A belongs to covered agreement? Yes, because all these agreements are subject to DSM. That means you can go to DSM for dispute settlement. And what about 1B, GATS? Can it go to DSM? Is it subject to DSM? Yes. 1C, just now I mentioned, can? Yes, good. What about this one? 2 itself, the DSU itself. Yes. Would it be covered by these covered agreements? Actually, no. No. What about C? Annex 3. Is Annex 3 TPRM covered agreement? No. No. What about the Annex 4, plurilateral agreements? We can see some of them are subject to DSM. Some of the plurilateral agreements are subject to DSM. Yeah. So where can we find all these agreements? No worry, there is an instrument. It's called Appendix 2. Appendix 2 to DSU. Appendix 2 to DSU. Appendix means annex. Okay? In this instrument, all the covered agreements, you can find them. Okay? Good. Good. Okay, in this part, and this is Annex 3, right? Annex 3, TPRM. You can have a browse of it. But as I told you, this part is not subject to DSM. You cannot bring a dispute before WTO dispute settlement body and for dispute resolution, no. And plurilateral agreement means Annex 4, plurilateral agreements. All agreements in Annexes 1 to 3 binding on all WTO members. This is the definition for plurilateral agreements. Okay. As you can see here, the first plurilateral agreement is the Agreement on Trade in Civil Aircraft. And disputes relating to this agreement cannot be brought to the WTO dispute settlement. But others, yes. That's why I say some of the agreements of plurilateral agreements are subject to DSM. Okay. You need to know what the function is of the TPRM. What's the function? You can find the answer in this paragraph. What's the function of TPRM? I mean Annex 3. What is its function? And there's also one thing I need to know. I need to highlight is this one. WTO members are free to discriminate in favor of domestic products, services, and service suppliers. That means it's a legal discrimination, legitimate discrimination. What does that mean? Why? You know, we've got a principle, a basic principle called non-discrimination, right? MFN, NT, all about non-discrimination. But here, about government procurement. You know, government procurement means? Procure means what? Buy. Procure something means buy something, right? Government procurement. What's government procurement for? I'd like to invite someone to give me a try. Okay, have a try. What do you know about government procurement? And all these products are bought for what use? Okay, nice try. Sit down, please. Okay. Government procurement is a special economic activity. Is it similar to private activities, economic activities? No, it's a special one. And in this context, we allow the governments to buy only domestic products to support its domestic industry. That's an exception. And that's a privilege. Privilege. It's a privilege. For example, nowadays, the Chinese governments are always free to buy domestic computers, right? Yes, computers produced, manufactured by Apple, not allowed, or Microsoft, no, including the software. That's something about government procurement. It's legitimate or legal discrimination against foreign products, services, and service suppliers. Okay, good. That's everything about the principal source of WTO law. Again, what's the name of the principal source of WTO law? What's the correct answer? The WTO agreement and its annexes, right? Okay, good. Then, next part, we will go to section 3, other sources of WTO law. Oh, I missed another important question or issue. Oh, question again. It's about this one. We know Annex 2 to the WTO agreement is DSO, right? Good. Annex 3 to the WTO agreement is TPRM, right? Then, so we can say, we can give these two a name, a common name for these two. What kind of rules are they? To put it another way, is TPRM substantive rules or procedural rules? Li Keyi, what do you think? What do you think? Have a guess.
Sorry.
Okay, sit, please. Never mind. Just give a guess. Have a try, okay? If I'm not mistaken, you are... Okay. What about you? Is TPRM a procedural rules or substantive rules?
No, I don't know.
What about you, Jinye? Why are you establishing barrier?
Procedure.
Procedural one, right? Let's try. And it's a correct guess. Good. It is a procedural rules. TPRM. Together with the DSU. They are procedural rules, okay? What about plurilateral agreements? Are they procedural one or substantive one? Substantive rules. Good, very good. Exactly. Now let's go to section 3, other sources of WTO law. First, you need to know what is included in there. There are 9 groups of other sources of WTO law. They are listed here, as you can see it. 9 groups. And we don't have enough time to deal with all of them. I only choose 4 of them. Okay. But before doing that, you need to know what's the function of these other sources of WTO law. And in other words, what's the difference between the principal source and the other sources of WTO law? There must be some differences. Otherwise, why would we distinguish them? Right? What's the difference between the principal and the other sources of WTO law? Look at the principal ones. You can, these agreements can always create or generate specific rights and obligations for the parties, for the members. But these sources, they do not. They seldom generate specific rights and obligations for the parties, for the members. Then what's their function? Look here, clarifying or defining the law. Clarifying or defining the principal source. What does clarify and define means? To interpret, right? Give some interpretations. How to understand the provision in GATT 1994? We don't know. We need an interpretation. How to interpret it with the assistance of these other sources of WTO law. So the difference or the distinction lies in here. Whether can it generate specific rights and obligations for the members or for the parties. Got it? Okay. Again, not everything. We can see most of them. I mean, some of the other sources can also generate specific rights and obligations. What is it? Look at here. Most. Look, most of the other sources do not provide specific enforceable rights and obligations. But there are some of them can. Which one? Guess. There's only one exception. Can you file a WTO complaint on the basis of customary international law? Think about it. customary international law. For example, good faith is a principle of customary international law. Can you bring a WTO dispute on the basis of good faith? Just go to the WTO. He is not in good faith. I'll sue him. No, of course not. It's not specific, right? Too general. So these are the basis you can file a complaint, right? Customary international law, no. It only assists in the interpretation, right? Good. I'll give you a hint, or I will tell you directly which one of these 9 other sources that can also generate specific rights and obligations. It's this 2 acts of WTO bodies. Second one. Before going there, I said there's a ghost in it. Maybe next time I will bring a flipper. You know flipper? No. In Chinese it's called, I will not talk about Chinese. You consult the dictionary. Okay. Before going to acts of WTO bodies, I will go to first one, dispute settlement reports. Dispute settlement reports, we can have panel reports, right? Panel reports. We also have appellate body reports. We have 2 levels or 2 instances of dispute settlement procedure. First instance, second instance. Okay? Then, if there is no appeal, then this panel report is enforceable. If there is an appeal, then the AB reports are necessary. What's the legal meaning of these 2 reports? They are the most important source of clarifications and interpretations of WTO law. The most important. But can they generate specific rights and obligations for the members to file complaints on? No. Although they are important sources, they cannot generate specific rights and obligations. They're just for interpretation. Okay. And what does get acquis mean? That means the get acquis, all the reports means get acquis. All the reports means get acquis, means existing laws and rules. Trust me, you can never find this word, acquis. Maybe it's a Latin word, something like that. But these reports generate legitimate expectations. Legitimate expectations. Now let's come to B, acts of WTO bodies. And this type of WTO source can generate specific rights and obligations for the parties to file complaints on. The authoritative interpretations. Only those specified in Article 9.2 and 9.3. Authoritative interpretations can generate specific rights and obligations. Okay. You can have a browse a bit. We'll move on. C, agreement concluded in the context of the WTO, subsection C. There's an interesting question. What is agreements concluded in the context of the WTO? China. I'll give you an example about China. The relevance of protocols of accession. China is not an original member of the WTO, right? The WTO was established in 1995. China enters into that organization in 2001. Right? China is not an original member. So, when China enters the organization, it signs an agreement. It's called Protocol of Accession. China's Protocol of Accession. 中国加入议定书. China's Protocols of Accession. This agreement is a subsequent, we say, agreement. No, it's just an agreement. It's an agreement, but the protocols of accession are integral parts of the WTO agreement. Although it's newly signed, but it's also an integral part, indivisible part. Integral means indivisible. Indivisible, cannot be divided. It's an integral part. For example, Taiwan is an integral part of China. Okay. Integral part of the WTO agreement. In these two cases, China Auto Parts and the China Publications and Audiovisual Products and China Raw Materials, these three cases, the China's Protocol of Accession plays a part. Question: can these protocols of accession generate specific rights and obligations? Can China's protocols of accession generate specific rights and obligations? Yes or no? Choose. Yes. Good. That's a correct guess. Why? There are three cases playing part here. Three cases regarding China's, right? Okay, good. Okay. The fourth of other sources of WTO law. Question, the similar question would be, can this generate specific rights and obligations for the members? Can? As you can see, interpretation. So it's a no. It's a no. But there is a question regarding state practice in public international law. For your recall. The question is, what are the requirements for state practice in public international law? For customary international law, there are two elements, right? First one would be state practice. The second would be juris opinio. Then the state practice, what are the features or characteristics of the state practice? Or we say, what are the requirements for state practice? They must be in Chinese. Can you guess? How many words? Yeah. Long-standing, maybe. What else? Consistent. What about consistent? Yeah. Long-term, consistent. Look at it here. Concordant means consistent. Common and consistent. Something like that. Okay. And also it's a sequence of acts. What about an isolated act? Only happened once. Can it become state practice? Of course not. Must be repeated, right? Repeated acts. Repeated acts. A sequence of acts or pronouncements, which is sufficient to establish a discernible pattern. An isolated act is generally not sufficient to establish a subsequent practice. Something like it's a little similar to state practice. Just a little similar to. Okay, I think, and this page is Article 31 of VCLT. What does VCLT mean? Vienna Convention on the Law of Treaties. And there are two, actually there's one extremely important article. It's Article 31. It's about the interpretation of international law. How to interpret international law. Article 31. A, B, C, D. 4 paragraphs. Very important. I suggest you read this article over and over again, okay? Because it's important. Another very important article is Article 38 of the ICJ statute. What's it about? Article 38 of the ICJ statute. It's about the sources of international law, right? And that's, so for example, customary international law, international treaties, the decisions of ICJ, and the general principles of law, and what else? The teachings of most highly qualified publicists, something like that. 5, and we have 2 principal ones, 3 subsidiary sources, okay? Good. That would be everything for chapter 2. Okay. Next week, we will move on to chapter 3, the WTO organization, the institutional rules. You can first guess, where are these rules? The WTO agreement or its annexes? There must be some provisions. Where are they? About the institutional rules. First guess, okay? And there's a very important thing I missed last week. It's about what? It's about page 20. Page 20. Yeah, here. Among non-other tariff barriers, the lack of transparency of national trade regulations definitely stands out as a major barrier to international trade. I need to tell you something about the barriers, how to distinguish between different barriers. First big category of barriers would be tariff barriers. And the second category of barriers would be how can we make it a complete whole, like this one. There are always two parts, right? If there are tariff barriers, then we have non-tariff barriers. Okay? Then we will divide these again. Tariff barriers, there are two types or subcategories. First one is customs duties. Second would be other duties. And the financial charges. And these non-tariff barriers, we have quantitative, restrictions, and other non-tariff barriers. This is clear. And further, the other non-tariff barriers, there are seven types. There are seven other non-tariff barriers. And the first one stands out would be this one. The transparency of national trade regulations stand out. That one belongs to one of the sevens, and the first of the seven other non-tariff barriers. Okay? Next class, during next week's first period, I will ask you, what's the first of the seven non-other tariff barriers? What's the first? Transparency of national trade regulations. It's on page 20. Read this page. It's Chinese version. And it stands out as a major barrier to international trade. That means the laws, the rules, regulations of a sovereign country, a WTO member, not transparent. We don't know. For example, I would like to do business with the United States, but I have no idea about the laws and regulations of the United States. They're not transparent. It's not predictable. It's unpredictable. So this is very good. And that's why look, not end of the class. And that's why we need a TPRM. TPRM is for what? For the WTO members to report their own laws to the WTO, so that every member would know them. And there will be regular reviews of WTO members' laws and rules on international trade. That's it. Any more questions? Right now, I can recognize each and every single of you, your faces, your names, all of them. There are 2 students or 3 who are not here, but they already asked leave. So they have also got legitimate excuses. I hope you can insist, right? Gradually, you will be able to understand what I'm talking about. Gradually, you will be able to get there. You will get there, okay? Good. Well, until we meet again. Bye-bye.